Good afternoon. The Appellate Division First Department is now in session. Nice to see everybody. Hope everyone is feeling well. Sorry we can't see you in the courtroom, but hopefully we will be able to do that again soon. I am going to call the calendar and I will let you know how much time you've been given, which you should already know. If somebody comes in that didn't check in with the chief clerk before, and I see one person has done that, you can let us know. Otherwise, we'll mark those cases submitted. So calling the calendar, People versus Carlos Garcia. The appellant has 4 minutes and 1 for rebuttal. The respondent has 4 minutes. Manuel versus Denbin. I believe the appellant has just appeared. I saw that you were waiting in the lobby. Mr. Pugh, you're here? Mr. Pugh, do you hear me? Well, I see him on, so I'm going to say that he has 5 minutes and 2 for rebuttal, and each of the respondents has 4 minutes, and hopefully this will get worked out by the time we get to your case. C. Jalissa, the appellant has 4 minutes and 2 for rebuttal. The respondent has 4 minutes. People versus Parker is submitted. Wesco Insurance versus Rutgers Insurance. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. People versus Boone. I don't believe anyone has appeared, so that case is marked submitted. Rios versus Sandowski. The appellant has 5 minutes and 1 for rebuttal. The respondent has 5 minutes. Newman versus Newman. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. People versus Escalona. I don't believe anyone has shown up, so that case will be marked submitted. Gutierrez versus Turner Towers Corporation. The appellant has 6 minutes and 2 for rebuttal. The respondent Triborough has 3 minutes, the respondent Pofi has 3 minutes, and the plaintiff respondent has 3 minutes. L&M 353 versus Steinman. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Yakik versus New York City Department of Education. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Wells Fargo versus Hayden. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. People versus Rosado. I do not believe anyone has appeared, so I will be marking that case submitted. Eos Helios versus Chohan, that is submitted. Sky Coverage versus Alwex, that case is submitted. And Pietronel versus Smiley and Smiley, that case is submitted. I will be keeping time as best as I can, and we'll let you know when the time is up. Please, if the judges still have questions, we will continue on, even if the time is up. Everybody, please be careful not to speak over each other. It's bad enough in the courtroom. It's a lot worse, as you know, when we're on Teams. Remember, we have read your briefs, we've had your records, and so try to just, we know what your case is about. Try to get into the heart of it. Please introduce yourself by name before you start your arguments, and please keep your microphones muted until your case is called. So hopefully it will all go well this afternoon. The first case for argument is People versus Carlos Garcia.
Good afternoon, Your Honors. Jerome Ma for Appellant Carlos Garcia. May I
Good
please...
afternoon, Mr. Ma. You may begin.
There are 4 reasons why Mr. Garcia should not serve a sentence over the statutory minimum. 1, Mr. Garcia has a minimal and nonviolent record. 2, the quality of his character through his strong work ethic and work history since leaving school in the 9th grade to work, and the fact that he's a family man who supports his aging mother shows that the instant offense is an aberration and out of his character. 3, for the instant offense, not only were Mr. Garcia's actions incongruent with his character, but they were not premeditated either. Rather, they came from a place of fear. And 4, Mr. Garcia's positive mitigating qualities, including his
Well,
acceptance of
Mr.
responsibility.
Ma, this is a case where we have all seen the videotape of what went on there, and so I'm responding to your statement about this being coming from a place of fear. I mean, Mr. Garcia was behind the counter. He was working. He was making sandwiches, working the register, taking care of clients. And there was some yelling going back, although there was no audio, at least on my video. And there was obviously some yelling going on between the other coworker and Mr. Garcia. However, if he had just stayed behind the counter or walked out that back door, there would have been no reason to have a confrontation, a physical confrontation with the complainant, even though he was yelling and may have been drunk. I mean, I didn't see anything that he approached him or maybe said, let's go outside, but nobody was near each other. So I'm wondering, the coming from a fear position is what I'm questioning.
Well, yes, Your Honor. Mr. Garcia acted the way he did because he felt that he was in danger, even though um, everyone around them, between the two parties, weren't necessarily fearful. Imagine hearing all those remarks and insults and being hurled at Mr. Garcia. And it doesn't excuse his actions. He acknowledges and admits that what he did was wrong. I would point to the court that this is similar
I
to how
actually, counsel, I have a question. When you say he admits that it's wrong, when he also says that he did it as a matter of self-defense, that suggests to me that he doesn't really think it was wrong, because I just don't see where the self-defense is justified in this situation where he was protected by a barrier. There was no physical threat to him, and the only physical threat occurred when Mr. Garcia stepped out from behind the barrier. But before that, he wasn't. So when you say he acknowledges responsibility, I don't understand how that's consistent with his, what seems to me a very unjustified claim for self-defense.
Well, you're right, Your Honor. This claim doesn't. The facts of this claim do not rise to the level of self-defense, and it was just the fact that Mr. Garcia was very on edge. He knew that there were past robberies in the past in the store, and the fact that he just felt that if he was ever in that sense of fear, if once he felt that, he knew that there was only one place to go, and he was basically
counsel. In fact, there wasn't only one place to go. There was a back door from which he could have exited. But let's move on from that point. My question is, this was a negotiated plea, correct?
That's correct.
So this information about him being a family man, whatever allegations of whether unfounded or not, that he might have been fearful, all of this would have been known to the court below prior to him taking the plea, correct?
That's correct, Your Honor.
And this was negotiated between, it was a B violent felony offense. He got 1 year above the minimum, right?
That's correct, Your Honor.
Okay.
Counsel, I have a question. Can you address Mr. Garcia's 2 violation convictions, 3 bench warrants, 1 non-expiring order of protection, 2 warrants for open cases at the time of sentencing, and also, I believe, a probation revocation, as well as 3 misdemeanor convictions. Can you address that?
Absolutely, Your Honor. I actually want to note that on page 21 on the People's opposition brief, the people rely on incorrect warrant information listed on Mr. Garcia's pre-sentencing report to characterize that Mr. Garcia has a propensity to commit assaults. But those outstanding warrants are for a different different Carlos Garcia. We obtained crimes reports by running Mr. Garcia's NICID in Rockland and Orange counties where those warrants originated. And I also made a call to the El Paso County Sheriff's Office and asked if there were any matches. There were no matches for my client, and I can provide the reports if the court so requests.
Okay, we're going to hear from the respondent, and you'll have a little bit of time to rebut it, Mr. Ma. Thank you very much.
Thank you, Your Honor.
Respondent, please.
Good afternoon, and may it please the court. Faith DeTrolio for the people.
Good afternoon.
In this case, defendant received a fair and appropriate sentence as a part of a negotiated plea agreement. Defendant received the exact sentence for which he bargained and to which he consented. And moreover, the sentence defendant received was a lenient sentence at that. Defendant was convicted for first-degree assault after viciously attacking an unarmed man with a knife. Still, he only received 6 years in prison, a sentence barely above the minimum. Also, defendant was initially charged by the grand jury with 2 counts of first-degree assault. The attack was captured on surveillance video and defendant admitted to it, making his conviction after trial almost a certainty. Thus, given his 25-year sentencing exposure if convicted after trial, defendant benefited greatly from his plea agreement. Further, defendants claim that the PSR includes incorrect information is unpreserved. The information contained in the PSR was not challenged below or in either of defendants.
Excuse me, but when you say that he was charged with 2 counts, what's your point?
My point is that if he was convicted at trial, he could have been convicted of both of those counts. And so he could have faced up to 25 years in prison. Instead, he got a sentence of only 6 years.
But they couldn't have been consecutive. They arose out of the same incident, right? Or it's not, there wasn't a separate assault, was there?
No, it's the same incident.
So he could have gotten that same sentence for 1 count, right?
That's correct. About the PSR, so the fact that this claim was brought to the people's attention less than 2 days ago has not given us an opportunity to fully investigate it. But regardless, defendant still has a criminal history and so presents a future risk of reoffense. And even without the criminal history, defendant still received a lenient sentence and so is not entitled to further leniency now. If there are no further questions, we ask that you affirm. Thank you.
Okay, thank you. Mr. Ma, any rebuttal?
Yes, Your Honors. First, this is Mr. Garcia's one and only felony conviction. His earlier convictions were for nonviolent petty offenses such as theft, trespass, possession of marijuana. He also had a youthful offender adjudication when he was 18, but these offenses occurred at least 2 decades ago. Since then, he's led a life premised on hard work and discipline. And second, the instant offense is out of character for Mr. Garcia. He's held numerous jobs as a meat packer in the Bronx, a barista at Starbucks. He worked in packaging and inventory at Orion Fashions in Midtown, catering at Manzoni Catering. And he's a family man who supports his aging mother.
Counsel, let me ask you a question. In some ways, isn't the fact that it's out of character almost frightening in itself? I mean, that watching the video, it seems with no provocation, he went, and with no physical provocation, he went from being behind a counter to slashing someone very violently. So isn't that a little frightening, in fact?
Well, the extra year in incarceration, well, those are there are many goals of the criminal justice system, and it's to protect society, deter future criminal acts, rehabilitate, and isolate. But the extra year behind bars doesn't further any of those goals. He would be equally deterred from engaging in future acts with a 5-year sentence, exactly with a 6-year sentence. This society is protected because.
So why didn't he bargain for a 5-year sentence?
Well, as you know, Your Honors, this plea bargaining process doesn't grant any defendant any meaningful leverage. It's like a Hobson's choice. It's, I'll give you a choice, take it or leave it. And where leaving it leaves the punishment highly uncertain. So it was foreseeable that Mr. Garcia would have taken the plea agreement, but that doesn't preclude the fact that this court has the authority to review his case de novo.
Okay, any further questions? All right, well, thank you both very much. Mr. Ma, I believe that you are with the firm of Kramer, Levin, Naftalis, and Frankel, and are working with the Legal Aid Society on this case. And we want to thank you for your pro bono efforts and ask you to please thank your law firm for that also.
Thank you, Your Honor.
Okay, thank you both, counsel, very much. Have a good afternoon.
You too.
The next case for oral argument is Manuel versus Denbin and Urbaio. I believe everybody is here now. So Mr. Pugh, you have 5 minutes for your argument, okay? But I think you seem to be on mute, Mr. Pugh, so please unmute your computer.
Can you hear me now?
Yes, we can hear you now.
Okay.
Okay, go ahead.
This is a legal malpractice case. The lower court granted respondents motions for summary judgment, but we contend that this was error. First, there were conflicting expert opinions. And there's case law that says when there are conflicting expert opinions, you can't grant summary judgment because those opinions raise a question of fact as to liability.
Well, generally, I might agree with you that very frequently we do say if there's conflicting expert opinions, but here I think we don't even get to the expert opinions because some of the law is not quite there. I mean, I wondered if you could go, sort of get before that and explain how you make out the claims for malpractice in this case.
Okay. Our most serious complaint was that respondents failed to submit a consent order. Do I need to back up?
No, we're familiar with the record, so you go right ahead. Thank you.
Our most serious contention was that respondents failed to submit a consent order that Dr. Manuel had entered into with the prosecutor for the body that disciplines physicians, and that had he submitted that order to the body that regulates who can treat Medicaid patients, he would have been permitted to continue treating Medicaid patients.
But wasn't the reason for the failure to do that the offer was made with a very short time frame so that there wasn't enough time to resubmit it for review?
No, there's a question of fact as to that. First of all, the prosecutor had told Respondent Denbin that there was a limited amount of time to accept the offer. But that's ambiguous. There's a question of fact as to what was a limited amount of time. If it was more than a week, then there was time to submit the consent order to the OMIG. And that's because another lawyer that specializes in attorneys' discipline, Amy Kolb, had written to me an email saying that she had had a response from the OMIG within a week. Does that answer your question?
Did that expert explain the source of her knowledge as to the time frame?
Well, her specialty was in the disciplining of physicians, so that she would have known from personal experience that you could get an answer within a week. But at a minimum, there was a question of fact as to whether there was time to submit the consent order to the OMIG for preclearance. And we know that submitting the order to the OMIG for preclearance would have resulted in Dr. Manuel being permitted to continuing to treat Medicaid patients. That's because we attached to our pleading a chart of what happened to people, to physicians who had been given probation and subjected to a fine. In 35 out of 35 cases, people who were given such lenient punishment as that were permitted to continue treating Medicaid patients.
Okay, any further questions? Well, let's hear from the respondents, Mr. Pugh, and then you'll have a couple minutes for rebuttal, okay?
Okay, could I just say a couple other things?
Well, actually, the time is up, so if you could hold on to those thoughts, make a note, we'll definitely listen to them on rebuttal. May I hear for counsel for defendant Denbin?
Yes, thank you, Your Honor. May it please the court, Young Yu Botul Scrivo for Nathan Denbin and Denbin and Associates. I'll start with the issue of OMIG and the pre-clearance issue because that's kind of where we left off here. I do have a few responses that I think are important, and really the context is important. My client was called on the eve of trial. They had tried to negotiate a settlement with OPMC. This panel, I'm sure, is familiar with the serious allegations and nature of the charges that were in the statement of charges by OPMC. And ultimately, through my client's performance at trial, he was able to put this case into position to settle and obtain a deal with OPMC that was never offered to plaintiff before. And I do want to kind of hone in on the standard for legal malpractice and what that is. And I think the standard really is, was it reasonable for my clients to, at the time, consider entering into a deal as soon as possible, given the situation, given the fact that plaintiff admitted at his deposition that he knew he was not going to be able to succeed at the hearing. And at that point, there was a real fear about plaintiff losing his ability to practice medicine at all. Ultimately, the deal that was reached was 36 months probation, a $5,000 fine, and we talked about the issue of timing, and I appreciate the panel picking up on that because plaintiff admitted at his deposition that there was an urgency to get the deal done. We can talk back about. Look back as to the timeline of the events, and we know that the consent order was provided by OPMC to plaintiff on May 21st. It was signed the next day by plaintiff, and the deal was entered into by the OPMC on May 26th. That's 5 days, Your Honor. Plaintiff raises an issue about an attorney named Amy Kolb, who's not even an expert in this case. She's never been identified as an expert in this case. She presented some evidence or reported evidence that what I would say is hearsay in opposition to our motion for summary judgment in the trial court to say that, no, it takes 7 days. It doesn't take 2 weeks. But frankly, Your Honor, that doesn't get to the heart of the statement of charges. And we know that's the truth because these are the same arguments that Ms. Kolb, as successor counsel, presented to OPMC, saying my clients didn't present the consent order before entering into the consent order with OPMC to OMIG to ensure that he wouldn't be suspended by OMIG. OPMC, director of OPMC, Roy Emerson, responded, the statement of charges that you're trying to compare with the statement of charges that that your client was facing does not even compare at all, because the charges that your client was facing, as in plaintiff, was far more egregious than the other cases cited by plaintiff in this case. Plaintiff's counsel talked about the 35 out of 30 cases. Those are all the same cases in the record that were presented to Roy Emerson at OPMC, who's a director there, who said, that's not going to fly. It doesn't matter. What we care about is the serious nature of the charges, not the consequences that was brokered between the attorney and the agency. And I just want to go back to the purpose of OMIG and why that independent agency was created. It was established years ago to detect and prevent fraud, waste, abuse of the Medicaid program. I mean, those are precisely the kind of charges that plaintiff was trying to address at the hearing, but could not provide an adequate defense for. Those were the precise charges, to be clear, that plaintiff said he had no chance of succeeding or defending in his favor. I mean, just to go through the list, I mean, negligence, performing unnecessary surgery on unwitting patients just to ramp up reimbursement rates, incompetence, fraudulent practice, false reporting. Those are things that the OMIG has discretion to consider to see whether or not this physician should be entitled to continue billing Medicaid. And I can continue going on, but I'm not sure if my 4 minutes is up, Your Honors.
Well, actually, it is. So maybe your co-defendant will pick up on some of the points that you started to raise, but I think we got the point. So nobody has any other questions. Mr. Urbaio, we'll hear from you. Thank you, Mr. Yu.
Thank you very much, Your Honor.
Thank you, Your Honors. My name is Ralph Urbaio. I'm a respondent and an attorney and representing myself in this case. I just want to pick up on a few things. I won't overburden the court by re-arguing that Mr. Yu mentioned. I just want to say in reference to OMIG, OMIG does decide cases not based on the punishment, but based on the statement of charges, and these statement of charges were exceedingly serious charges. And also, I did present in my reply brief to the court below cases where and a physician was suspended, but OMIG did not reverse a disqualification. And also, I wanted to also raise what Mr. Yu raised about the timing. As I presented in an expert affidavit I presented from a Douglas Najari. It very well could have been where if we had not executed the consent in a timely fashion, that OMIG would have withdrawn, OPMC would have withdrawn the offer, and then the doctor would have been faced with going through a hearing which he had very little chance of succeeding at, and which would have almost certainly ended in a more severe penalty, which could have resulted in the termination of the revocation of his license. Mr. Denbin basically was able to obtain a very favorable outcome for the doctor, especially when faced with all these charges. And the doctor knew full well all of the ramifications that could result from signing this order, but he made a decision based upon what was happening at the hearing to sign the order, which resulted in him being able to continue to practice medicine rather than face a hearing, which would have probably resulted in a termination and revocation of his license.
Okay, thank you very much. We appreciate hearing your positions. Mr. Pugh, you have 2 minutes to respond to anything you'd like to respond to.
Yes, with respect to Mr. Urbaio, his motion for summary judgment should not have been granted at all because it was untimely. When he made the motion, he did not give an excuse for the untimeliness. He only gave the excuse in his reply papers. And we've cited case law that under those circumstances, it would have been improper to consider the excuse.
Well, Mr. Pugh, in this particular case, again, I often might agree with you, but in this particular case, this time limitations had been told because of the pandemic-related executive orders, which told motion deadlines. So really, I don't think that he had to say that. I mean, they were told for quite a period of time. So I don't think it was necessary that he had to argue that. It wasn't like reasonable excuse or something. I mean, we were in a kind of an emergency situation at that point. So why don't you go on to some of the, if you want some of the factual issues that they raised.
Okay. Down below, Mr. Urbaio said that there was going to be a second hearing. And that was the reason, and everybody wanted to avoid the second hearing. But he doesn't say when the second hearing was going to be. So there may have been time to submit the consent order to the OMIG. With respect to Respondent Denbin, let's assume for the sake of argument, he's right that the OMIG does consider the seriousness of the charges. At a minimum, there's a question of fact as to whether, given the leniency of the charges, given the leniency of the punishment imposed on Dr. Manuel, the OMIG would have barred him from continuing to treat Medicaid patients.
Do any of my colleagues have any further questions for Mr. Pugh? Okay, well, thank you all very much for the arguments. We'll take another look at all the papers. Have a good afternoon.
Thank you, Your Honors.
Thank you.
Your Honor.
The next case for argument is C. Jalissa. Mr. Young.
May it please the court, Bruce Young on behalf of the mother, Angela E. This case, the attorney for the child in support of appellant that the evidence is not supported in the record. The trial judges made inadequate findings that didn't find anything, so there's no credibility assessment. It seems like all the parties are asking the court to revisit the facts, and the facts don't support the theory that she knew or should have known that her child was in danger, when the evidence is that at each critical stage, she, as any objective, reasonable parent under the Nicholson standard, took steps to alleviate any risk. And as it,
Mr. Young,
Yes?
Young, I have a question. Mr. Young, I have a question for you.
Yes, Judge Gesmer.
The mother did say, both in her own testimony and through and also the ACS worker recounted her telling her that she was aware that the child's father had a problem with abuse of alcohol and with mental issues, and nonetheless allowed him to take care of the child. Doesn't that to a certain extent corroborate the child's statements and also provide an independent basis for the finding of neglect?
It could have, but if we look carefully in the record, Judge Gesmer, thank you for asking that. The hearsay that was introduced on the direct case said, oh, she knew that he had a drinking problem.
Are you talking about the ACS workers?
Correct.
recounting of what the mother said? Well, that's not hearsay. It's a statement against interest.
Well, it was,
So it's not, it's an exception to hearsay, isn't it?
what I'm getting at is if that established any kind of a prima facie case, when she did in fact take the stand and testified at length about everything and every single detail, she rebutted that presumption. So at that stage, I think you can't look at it just as like a two-dimensional flat screen. There's a dynamic as to how it transpired. So when she finally had the opportunity to describe what she did, if she perceived a risk, what steps did she take?
But Mr. Young, I don't understand. She didn't dispute having said that to the ACS worker, did she?
She disputed the degree. She said that she knew that he had drunk, but when she said I never said that he was an alcoholic, that was, outside of any control, anything. When she was working two jobs, when the child expressed any concern, she immediately got a babysitter. When she said he hit her or she had fear, she said there's no discipline. When there was anything about this bath issue that occurred, one, she didn't have any thought, never had it given any authority to give the child a bath. And when that happened, she immediately threw him out of the house, changed the locks, and took the steps. So the delicacy of the child protective intruding into the family's role to see what's going on one way or the other was, I think, met. I think the evidence in this record, and I think it's belied by Judge Richardson, did not make any findings. At the end of the conclusion, he says, I'll make findings. And then when the findings came up just before disposition, he said, well, but that was then and this is now. And he then moved towards a trial discharge, which was finalized towards that child. So I don't
Mr. Young, I have a question. I'd like to go back because
Sure.
the mother did admit that the child told her that she was afraid of the boyfriend because he hit her. Now, certainly, while the mother hired a babysitter, she certainly did not discontinue the boyfriend's unsupervised care of the child altogether. He still cared for the child unsupervised, in spite of the fact that the child told her she was afraid of the boyfriend.
I don't know that I could point to a page number, but I believe in time, as when that fear was revealed to her, she took steps to bring back the babysitter or send the child to the babysitter so that in fact there wasn't any or as much supervised access to it wasn't the father, but the person legally responsible, the boyfriend in the home. So
But
I think
counsel, the fact of the matter is there was still unsupervised access.
Right. So if we look at it from an objective, reasonable parent under the Nicholson standard, and you say, okay, he did one thing wrong, out of the house, lock the doors, whatever. I don't know that would be commensurate with that. She acknowledged and respected her daughter's fear or concern, and she took prompt, commensurate steps to overcome whatever that fear was. And when that wasn't, then she took a further step. She worked cooperatively with any ACS investigation. When anything was brought to her attention, she took steps that I think we can't hold this in a vacuum and only affect it one way or another. This is any objective parent's reasonable steps. And I think that's the standard that ACS failed to establish in this case.
Okay, we're going to hear from ACS now, and Mr. Young, you'll have 2 minutes for rebuttal. Thank you very much. You may proceed.
Good afternoon, Your Honors. Kevin Osowski on behalf of Administration for Children's Services. It's undisputed that the mother told ACS that the stepfather was an alcoholic with mental health issues who drinks daily in front of the child, and that the mother knew that her 6-year-old daughter was afraid of the stepfather because he had hit and scratched her, yet she repeatedly left the child in his care overnight. The mother's failure.
Counsel, the statements that you just made, were those corroborated by the mother's statement or by something else?
She admitted in her testimony that she had told ACS about the stepfather's misuse of alcohol and his drinking and in front of in front of the child, and also that she was aware of her child's fear of the stepfather because of his hitting and scratching her. And that is corroborated by the videotape statements by the child. But the court doesn't need to. Justice Ginsburg, sorry.
Wasn't there also evidence that once she became aware that the child said that he had hit and scratched her, that she no longer left him in charge of the child?
Your Honor, her testimony was that she decreased the amount of time that he was spending with the child, but it was not that she didn't say that she stopped using the stepfather for overnight supervision or that he was prohibited from being alone with the child. And it was that decision. It was the decision to leave her 6-year-old daughter in the unsupervised care of this person that she herself described in terms that would qualify him as an unsuitable caregiver.
So are you saying
neglect?
Are you saying that the statement that as soon as she learned about this, she threw him out and changed the locks is not completely accurate?
It is not accurate. That's not what happened. She, as soon as she knew about the allegations of sexual misconduct, she took those types of steps. But before then, she knew about the stepfather's alcohol misuse and about his mental health issues, about his temperament issues that she also admitted to the ACS caseworker, and also about her daughter's fear of the stepfather and his excessive corporal punishment against the stepfather. And with all of that in mind, she still left her daughter in the stepfather's unsupervised care.
Do we have a problem? Oh, I'm sorry. Do we have a problem because Judge Richardson didn't really make the types of findings we might more extensive findings than he made in his decision? Is that a problem for us? Do we have to send it back to flesh out those findings some more?
You don't, Your Honor, and I don't think anyone would say that these findings of fact were particularly robust or that it was described in detail. But we do submit that it was adequate. The court both during the January 2020 hearing and in a separate written January 29th, 2020 family court order that appears on both a docket for the biological father and this docket. The family court said that the mother failed to protect the child from misconduct by the stepfather, and that it's supported by all the kind of facts that we were just discussing. If the court feels that finding was inadequately described or memorialized, this court has the authority to make a fact finding based on the full record that's before it. The mother acknowledges that on page 8 of her reply. And we would encourage this court to review the record and of course reach the same factual conclusion as the family court.
Counsel, in this case, the child's attorney agrees with the mother that there was not an adequate factual basis for a neglect finding. Isn't that unusual in this kind of case?
I can't speak to whether that's usual or not unusual. I would offer that the counsel for the child had the opportunity to appear and robustly defend his brief today, and has chosen to not do so. And that still doesn't negate the fact that the undisputed facts in the record here support family court's finding of fact.
Any further questions? Okay, thank you very much, counsel. Mr. Young. Thank you. Mr. Young, you have 2 minutes.
Thank you, Judge Kapnick. I would just initially suggest that whether or not the attorney for the child who wrote an extensive brief and its detailed findings didn't show up for oral argument today, I don't think we can make a negative inference against him in this instance. I think the mother's testimony and the evidence that was here, again, as an alarm or a fear or a concern was raised, I think it's undisputed that she immediately took prompt action to address that and increasingly close the circle of protection that the mother gave her. And when there was something that was urgent, then she immediately took steps to throw him out of the house, change the locks, and took steps. Those other steps, you can't just say, oh, the guy had a drinking problem in the past or something else, and then say, so you should never trust him with anything whatsoever. She was working 2 jobs, and she did not neglect her child. She took diligent steps to care for the child. And I think even Judge
Mr.
Rich.
Young, may I ask you one question?
Yes, Judge.
If the mother's statement that the stepfather had an alcohol problem, would that in itself have been enough to base a finding of neglect on, or to corroborate the child's statement without more?
If it had been something overt that was apparent and that she knew or should have known about his drinking, and that the recurrence of whatever the problem he'd had before, I think the statute is that she was not in any kind of rehabilitation program. If you're going to, like, ACS proving neglect against him for that purpose, she monitored it. She relied on whatever help you could give, and when it seemed inappropriate, she took immediate steps. Thank you very much.
Thank you both very much for your argument. Have a good afternoon. The next case for oral argument is, sorry, I lost a piece of paper. Wesco Insurance versus Rutgers Insurance. Okay, counsel for the appellant, is that Mr. Oops, I'm probably going to get your name wrong. So I'll let you, Mr. Verveniatos.
Verveniatos.
Okay, good afternoon. You have 5 minutes for argument.
Good afternoon, Your Honor. May it please the court. I represent the appellant Rutgers Insurance Company. This is a case that is a fight between two insurance companies regarding additional insured status. And my argument, to be plain and simple, is that the court below rushed through the process. There was no discovery afforded regarding the issues that are at play, and the motion papers that were submitted below were not sufficient to meet the burden of proof for summary judgment. The attorney for the insurance.
Why couldn't this have been decided just by a plain reading of the lease?
Well, first of all,
and the two insurance policies.
And the policies.
Right. First of all, nobody authenticated the lease in this case. You got one insurance company on one side submitting saying this is the lease. You got another insurance company on the other side, me
Counsel,
saying,
the lease was produced at the deposition of the tenant by the tenant's principal. So, and that was the same lease that was introduced on the motion. So I don't understand why that's not sufficient authentication. Once something has been produced by a principal and identified as such, why isn't that adequate?
Well, Your Honor, that was in another lawsuit. That wasn't in this lawsuit. I wasn't allowed to participate in that other lawsuit or have discovery. And more importantly, factually, is that there's a dispute about the provisions of that lease and what actually occurred. We saw in the deposition in that other action, because I also monitoring it, that they actually repaired this sidewalk, the property owner. The lease itself, even if you were to accept it, which I wasn't allowed to have discovery about and to cross-examine people about in this coverage case, is that the common areas were controlled by the landlord. This is a defect on the sidewalk that the property manager subsequently, we think, came and repaired. It had nothing to do, it was a nighttime accident.
But
had nothing to do with the store.
Excuse me, counsel. The lease provided that it was the tenant's obligation to maintain the sidewalk. So even though the accident occurred at a time when the store was closed, it was still the obligation of the tenant to maintain it. And even if the landlord chose to then come in and repair it, that doesn't vitiate the tenant's obligation to repair it.
No, Your Honor, not to interrupt. It did not say that the tenant repairs the sidewalk. It said that the landlord will maintain and control the common areas. The sidewalk.
In section 10.3 of the lease, it says that the tenant will repair and replace as needed the sidewalk. It says that.
Your Honors, the definition of the premises being insured and the additional insured coverage, this is why this is different in the liability case than in the coverage case. In the coverage case, it only applies to additional insured status with respect to an accident that has to do with the premises that the insured rents, the tenant rents. The premises is defined as not including the common areas. So the premises for additional insured status under the additional insured portion of the policy requires interpretation of what is actually leased to the premises, to the tenant. Since the sidewalk is not defined as part of the premises, and this accident had nothing to do with the operation of the store being a nighttime incident on the defective sidewalk, this isn't what they got additional insured coverage for.
Counsel, but doesn't your policy provide for coverage, quote, arising out of the maintenance or use of the premises, close quote? And wouldn't that include their obligation to maintain the sidewalk, which was included in the lease, as Justice Pitt said in paragraph 11.3 of the 10.3 of the lease?
No, Your Honor, it would not. That's my whole point. The additional insured coverage is different than whatever obligations to do things beyond the premises being leased under that's relevant in the liability case. So regardless of what the determinations are in the liability case, the wording of the additional insured coverage talks about the premises. This has nothing to do with the premises. The lease specifically says the sidewalk is not part of the premises. So that's why I wanted to have discovery about this. And again, I must repeat my initial point. Notwithstanding the fact that the lease was being used in another case where I had no opportunity to participate, it wasn't submitted by anyone with personal knowledge on the motion below. I wasn't examined to cross-examine anyone about the lease in this case. I wasn't a party to the other lawsuit. On a procedural basis alone, I cross-moved for discovery. I even subpoenaed the property manager, a non-party, to try to get the evidence about what the premises is and what the condition of the sidewalk and what the practice was regarding the sidewalk. Procedurally, the motion below was not properly adjudicated. It should not have been acceptable to have an attorney say, this is the lease from another case. It was not appropriate for the court to deny me the discovery to cross-examine somebody about the lease and the maintenance of the sidewalk and the difference between the premises and the sidewalk. Procedurally, I should have been granted my cross motion for discovery.
Okay, I think we understand the position that you're taking. We're going to hear from the other side, and you will have 2 minutes to respond to that.
Thank you,
Mr. Gershwire?
Yes, good afternoon, Your Honors. Max Gershwire for the respondent. This is
so what about the discovery issue that he's pushing on his appeal? Why was this not premature if he was still looking for some discovery before the summary judgment motion was heard?
Your Honor, as the record shows, we responded to their discovery demand. There was no pushback by Rutgers about the response. This was months before we filed the motion. And only when in that response, we say, because as the insurance company, we don't have any records regarding any maintenance of the sidewalk. And we said so in our response. So the counsel had an opportunity to object if there was anything objectionable about our discovery response. He didn't. And so we filed our motion. Had there been an issue, had he made an issue about the discovery response, we would have addressed it. But Your Honor, more importantly, and I think you hit upon this at the beginning of the argument, the only documents that matter in this insurance case are the insurance policies and the lease. That's it. It makes no difference who is responsible for maintaining the sidewalk under the well-settled law of this under this industry standard endorsement. It makes no difference. There's nothing in the additional insured endorsement that says anything about which party was responsible for maintaining the area. There's nothing in the endorsement that requires that the accident occurred within the leased premises. And in fact, this court, again, this is the fifth time I've argued this exact same issue before this court. That is whether this industry standard additional insured lessor provision covers the lessor for injury sustained on a budding sidewalk. Each and every time, this court has found the same way. There's coverage. Why insurance companies are even fighting this issue anymore is beyond me. This is something that the courts have continuously found, without exception. There is nothing that's novel about this case. The courts have previously addressed situations where the landlord was found to be responsible for the sidewalk. Here, this court has already determined in the underlying case, in a case just handed down just 1 month ago, on which Justice Kapnick and Justice Gessmer were on the panel, finding that the tenant in the related case was responsible for the sidewalk. Again, our position is that doesn't even matter. But to the extent that counsel is arguing that that's still a live issue, it's not. It has already been determined by this court just 1 month ago. So that issue is off the table. So again, this is a settled issue. Counsel makes all these arguments about the admissibility of evidence. You have the court can take judicial notice of the testimony that's part of the record from the people who actually have personal knowledge of the lease, that this is the lease. That is how, and the idea that counsel had no opportunity to cross-examine, well, his client assigned defense counsel to defend the tenant in the underlying case. So Rutgers itself had every opportunity to ask whatever questions and get whatever evidence they needed in the underlying case. So this idea that there's some sort of outstanding discovery.
There's no issue about the, I mean, he's raising, we're not, I wanted to have cross-examination, but is there really any authentic factual issue about the authenticity of this lease?
Of course not, Judge. Again, we submitted the testament. There's the copy of the lease that's in this record was marked at a deposition in the underlying case, and it was authenticated during that deposition, which we include as part of the record. So the idea that this is not properly authenticated is nonsense, to put it frankly.
Does anyone have any questions for Mr. Gershwire? Okay, well, thank you very much. We'll hear from the appellant. You have 2 minutes to respond to anything.
Thanks, Judge.
Yes, Your Honor. Responding to the last question that you just asked my adversary, I think it's procedurally improper for an attorney to say this is a lease and admit it into evidence. That should be a period, stop the sentence, stop the analysis. He has the burden of proof. Regardless of my opposition, he had the burden of proof below to submit it on the basis of admissible evidence. An attorney saying,
really, is there any, I'm going to ask you the same question I asked counsel. Is there really anything in the record to raise any factual issues as to the authenticity of this lease? I mean, it's not like some other lawsuit. It's the underlying case upon which this DJ action is based. So it's not like it's some unrelated case. It's the same lease, the same part, the same issue. So what's what's really the question here?
Well, that is the question, Your Honor. I did not have an opportunity to participate in that other lawsuit, and I don't know what issues there might be as to this lease. That's the whole point of having the hearsay rule. If I don't explore the issues as to whether this is an authentic lease or there are issues about it, if I'm not allowed any discovery about it, and the argument that you just heard before, they responded to my discovery demands by telling me that they're an insurance company and they don't have anything. They're the insurance company representing the property owner. They should have reached out to the property owner, given me the property owner's records, and allowed me to depose the property owner and the property manager, which I subpoenaed. The whole point is he didn't meet the burden of proof on the motion below. That's not a slight point. That's a big point. He didn't meet his burden of proof, and the motion should be denied upon that. I can't tell you what authenticity issues there are about that lease because I haven't had a chance to examine anyone about the lease. I don't know what the answer to that question is.
Okay.
But the point is that there's a different standard on their indemnification provisions. Additional insured status doesn't depend on whether the lease says you're entitled to get indemnity, property owner, from the tenant. My additional insured status, it is very different from other cases in which people have accidents while coming into the store, walking into the threshold, and there's a condition that happens. The fact that this is an accident that has nothing to do with the premises, which is defined as meaning anything but the sidewalk, and the additional insured coverage is derivative of the premises, not including the sidewalk, is important here, different than in the underlying case.
Okay, we will certainly take another look at that. Thank you both for the arguments. Have a very good afternoon.
Thank you.
The next case for oral argument is Rios versus Sandowski. Ms. Rios, I believe you are representing yourself, and you have 5 minutes for argument. Good afternoon. I think you're on mute, Ms. Rios. No, we can't hear you. Oh, okay.
Can you hear me now?
Yes, we
Sorry.
can. Go ahead.
I think I've written so much and I've said the same thing over and over again so many times. And I'm not an attorney and I'm very nervous. So would you just ask me whatever questions you have or if I can clear anything up for you, I will.
Well, I did have one question, Ms. Rios. The commission agreement indicates in there that the commission will be based upon the rents collected. Are you over a period of 5 years? Are you disputing that arrangement or that agreement?
A commission is calculated when you sign a lease. A broker's commission is a percentage of the value of the lease. So the rent that the tenant was supposed to pay over 5 years was $1.8 million, I believe, and my commission is a percentage of that. That's the standard way any broker computes a commission.
But wasn't there a particular?
Go ahead, Judge Mazzarelli.
Wasn't there a particular agreement that you had in this instance which differed from that standard practice?
No, the agreement that we had was the agreement that was the executed one, the one that I signed with Sandowski. That is the only agreement.
But doesn't that specific agreement say commission due for first 5-year lease, and then in parentheses 5% of gross rent collected over 5-year lease term? So Mr. Sandowski, I think the father, testified that it was his normal practice that if the particular tenant might not have had an established business, that rather than entering into what you're saying is the standard agreement, that he would put something like this in there and limit it to the amount of rent that was actually collected. And isn't that what it says here?
No, the commission is clear. It shows you exactly how the commission is calculated and the amount that's due. The fact that I put collected in there, that maybe I shouldn't have put that in there, but the amount that's due is, I mean, it's pretty standard. I mean, I actually, there's many cases of brokers who've sued for exactly the same type of commission. That is how you calculate a commission on a lease. And it's
in the case.
Go ahead.
When you say that that's how it's calculated, in those cases where it's been calculated that way, the commission agreement doesn't say on the amount collected. That's what's different about this one.
Right, but I think if you look at the agreement, it shows the amount that's due and when it's due. And when it's allowing the tenant to pay out over 18 months, as he was collecting rent from the tenant, he was supposed to pay me the $3,000 $3,035 over 18 months in order to exhaust the balance that was due, which was $59,000. They paid $5,000 of the commission. They understood the agreement. Their son was authorized. Orrin Sandowski was is an attorney. He had me revise this agreement. And the fact that his father actually said on the stand, he's not involved in the day-to-day operation. His son, who was an attorney, is the one who signed that agreement with me. And his son on the stand also said he had a permission to offer me that commission. And that is the industry standard. That's how a broker's paid. A broker is paid a percentage of a sale or an order. That's actually the way the Department of Labor defines a commission. I mean, this is standard. I mean, do you honestly think that that it's reasonable to expect me to wait 5 years to get paid my commission, or when and if the tenant defaults, you're going to give me 5% of an individual amount? I mean, nobody would earn a living that way. I mean, that's absolutely ludicrous for anybody to think that I would agree to that, or that that's what I meant. My commission is clear. The balance due was $59,000. They paid me $5,000. They owed me the balance in 18 installments. Once they obtained the TCO in October 2013, that's when the first payment had to be paid. And then every month they needed to pay 18 to exhaust that amount. That's it. The fact that word collected is there. And the law is clear is also a broker is entitled to.
Ms. Rios, let me ask you one other question, because I suspect this will be brought up by the Sandowski people. Is there a difference between Melinda Rios and Melinda Rios Inc. in terms of licensing for to real estate?
No, brokers are allowed to have their commissions paid to their corporation, and their corporation doesn't need a license. Their corporation only needs a license if they're going to be advertising that corporation in print, on TV, radio. If anybody wants to look up that entity's name, it has to be registered with the Department of State, so they give you a license, a corporate license. And you also need it if you have to sue, because you're not allowed to sue in the name of an unlicensed corporation. However, it's not required, and it's also New York Real Property Law 442, splitting commissions is clear. You are allowed to have a broker is allowed to pay a commission to an unlicensed corporation, provided that the principal of that unlicensed corporation is licensed with a real estate license.
Okay, Ms. Rios, thank you for answering all our questions. You did an excellent job for a non-lawyer. I wouldn't know you were not a lawyer. So we're going to listen to Mr. Spiegelman, and you'll have 2 minutes to respond after that. Okay, thank you. Mr. Spiegelman.
May it please the court. Good afternoon, Your Honors. David Spiegelman, I represent the respondent in this case. In short, I think Justice Billings' decision, which denied the amendment of the complaint, denied the summary judgment, and dismissed the breach of contract claims after the trial are clearly in line with precedent, and our brief discusses it in detail.
Counsel, let me just ask you one question, because the commission agreement does say based upon rents collected over a 5-year period, but then the payments were going to be distributed over 18 months. How do we reconcile that? Why would it be 18 months for payment if it's based upon 5 years worth of rent collected?
It should be noted that the use of the word collected wasn't an accident. The use of the word collected was done because this was a tenant who was not financially demonstrated to have the means to definitely honor the lease, and in fact was in default almost immediately. And that is why the structure was done that way. If at any point rent stopped getting collected, well, there you go. Then you wouldn't be owed a commission. And the language of the commission agreement supports that idea.
But I mean, go ahead. I mean, to follow up on Judge Pitt's question, I mean, it does talk about the collected over 5 years, but it also said that the commission was supposed to be paid in 18 months. So how would you know after 18 months what was going to happen for the next 3.5 years? So how do you like reconcile those two provisions in this particular commission fee agreement invoice?
The first point to make is that the commission agreement wasn't drafted by us or by my clients. It was drafted by Ms. Rios. The second.
Yeah, but you did sign it.
Correct.
Your client.
The second.
One of your clients is a lawyer.
Right.
My client does not practice and would, as I believe the adage goes, only a fool would represent themselves.
Well, he had you, but he is a lawyer. So I'm assuming he wasn't a fool. He had you as a lawyer, and, and he had a legal education. So he is presumed to be able to read a document and understand it from a legal perspective.
Yes, Your Honor, reading the document would mean that if the rents aren't collected, you wouldn't be paying a commission. However, why 18 months?
The question, Judge Kaepernick asked you is how do you reconcile those time periods?
Because if a tenant who has been to date over 18 months would demonstrate an ability to actually fulfill their obligation, it wouldn't be an issue.
So if they had paid rent for 18 months, she would have gotten her commission, and then they could have defaulted. She would have gotten her commission.
Melinda Rios Inc. would have gotten its commission.
We're not stay on topic here. We're talking about the 18 months, and I just want to know how you reconcile. Like, so if the tenant had paid for 18 months, the entire commission would have been paid. Then they could have defaulted, but the entire commission would have been paid. That doesn't make sense then, that it has to be based upon 5 years worth of rent collected.
Exactly.
Well, wait, don't respond to anything, Ms. Rios, until it's your turn, okay?
I didn't realize you could hear me, sorry.
Yeah.
You mute yourself for now.
The fact of the matter is that we should correct something. Orrin Sandowski wasn't the client. The client was his father. I just want a little clarity on that. Those two provisions, while they may not be perfectly in tune, they alleviate the concern of the owner in that an unproven tenant would at least be able to demonstrate an ability to pay. Regardless, the Melinda Rios Inc. wasn't a party in this case. That issue never even got fully litigated because, in truth, there was no contract to be breached. Ms. Rios had no standing to even assert this claim.
Well, it sounds like Mr. Sandowski, Orrin, didn't have any right to sign the document. It sounds like we got all the wrong people in this case. I mean, it made it very confusing here.
Mr. Sandowski there's no question that he was authorized and it was never denied.
Mm-hmm. Yes.
So he's authorized to sign it, but all right. Well, anything else? Do we have any other questions for Mr. Spiegelman? All right, Ms. Rios, you have 2 minutes to respond to anything that Mr. Spiegelman said or anything else you'd like to add, okay?
Yes, I would like to add that they don't have any evidence anywhere in the record that we agreed to any other form of payment other than the one that's exactly stated in my agreement. And Orrin had full authority. He admits that in deposition. His father admits it in the interrogatories. Plus, he signed the check that he gave me. Also, he paid me a check directly to me, Melinda Rios, not the corporation. So he had bank signing authority. He was fully authorized. His father is not there in the day-to-day operation. We never met him. There was also no evidence that the tenant was of any risk to them. In fact, the Orrin Sandowski and his father were a risk. That property had issues. The space needed to be permitted. It was a risk for me and Shayla of Mini Ventures to even get involved with these people because they already had sued the previous tenant and they also had a space that was not permitted that required Shayla a lot of money. It was a risk for her and to get the space permitted and then hope that he would get everything ready by the time, you know, school started. There were all these things that had to happen.
Okay, but I don't know if that's really, you know, doesn't really bear on the nature of the claims that you're making against him.
Well, but they keep saying that Shayla was a risk and that the commission was but she was not a risk. She had 2 fully operating daycare centers, one right down the street from their other daycare center. She was not a risk. There's no evidence of her being a risk.
Except she did stop paying the rent.
She didn't stop paying the rent. They stopped renewing the TCO, and the state that funded the rent held back her payments until the TCO was renewed. And when the TCO was renewed, the funds were released. That's also on record. That's also something that I discussed with Mr. Sandowski when he was on the stand. He always got his money. The reason that they ended up suing her or evicting her was because they had another tenant they wanted in there. They lost nothing. They only made money. They benefited from her. They used me, and then they didn't want to pay. They have no evidence of anything that they're saying. My commission is standard. I have many cases that I found after I filed my brief that show my commission is exactly the way every other broker in the state of New York and anywhere in the country drafts a commission. Commission is due as per the agreement, not per whenever they want to pay, as they want you to believe.
Okay, I want to thank both of you. We will take another look at these papers. The argument was very helpful, and thank you, Ms. Rios.
Everything is in the papers. Thank you.
Okay, we will look at them. Thank you both very much. Have a good afternoon.
Bye-bye.
Thank you.
The next case for oral argument is Newman versus Newman.
May it please the court, on behalf of defendant appellant Harvey Newman, the Janey Law Firm by Darrell Janey. Good afternoon.
Good afternoon.
In sum, without repeating in particular our submissions, which are lengthy, and I know the court has reviewed them, this appeal is about whether the First Department, its ruling and decision in Udell versus Gilbert in 2012, laying the framework for distinguishing between derivative claims and direct claims when they are brought in a lawsuit, and a single lawsuit by a shareholder, still stands. Our position is that Udell still stands, and it stands for the proposition that intermixed derivative and direct claims is grounds for dismissal, where the direct claims are based on the harm suffered by the corporate entity.
Except, isn't this situation, counsel, if I may, isn't this situation a little different from that in the sense that, well, in 2 ways. One, that because there's a familial relationship, there's also a personal breach of fiduciary duty claim. And in addition to that, there's also the possibility of individual criminal liability, which would go to Mr. Charles Newman. So that's an injury which would go to him personally, not just to the corporation. So isn't that a different situation than we normally have?
So let me respond with 3 comments, Your Honor, and preface them all by saying that on the law as we read it, I believe the answer is no. Now, let me elaborate on that if I can. One, the plaintiff respondent, as we describe in our reply brief at page 7, introduces 2 new arguments which were made below. One, they cite for the first time ever a First Department 2000 decision that recognizes, and I'm quoting from our reply brief, page 7, recognizing a direct claim for damages suffered by an oppressed shareholder in a family-owned shipping operation. That's at respondent's brief at 18. That was never made below, not part of the record below. And 2, they also, for the first time, and I'm reading from our papers at page 7 in our reply brief, respondents offer a New York slip opinion from 2018, a trial court decision for the proposition recognizing direct recovery may sometimes be more appropriate where the allegations of mismanagement and diversion of corporate assets result in a disproportionate loss to a shareholder, again at respondents 18. Neither of those are made below, and I believe the first piece of what they're arguing newly speaks to one of the things that Your Honor has just described. But with respect to the holding in Udell, and I'm only citing the case so I can give you the pin site, the site for Udell versus Gilbert is 99 Atlantic 3rd 108. And I'm looking specifically in the court's decision, the First Department's explication at 114 to 115. And there, in some, without reading the passage, Your Honor, that goes through to 115, the court is saying there that really, regardless of the circumstance, that where those are intermixed claims, regardless of whether it's a family ownership, regardless of the potential liabilities that might befall the defendant, that claim, because they are intermixed, is dismissed. And looking to the appendix that we have cited, Your Honor, there's no question that they are intermixed claims. And I respectfully refer the court to the appendix marked as 66 to 67.
Yeah, so I'm sorry to interrupt you. I mean, I have a copy of the Udell case right here because I read it in preparing for this case because I thought it was an important decision to read. And I see what you're saying and I see what it says. But my question is in this particular case, which is a 3211 motion to dismiss the individual claims, hasn't the plaintiff at least asserted individual claims that are not, that at least at this stage do not go to the damages or harm suffered by the corporation, namely that he may be exposed to personal criminal and civil liability as a result of defendant's conduct. Now, maybe he won't be able to prove that down the road, I don't know, but it is a 3211 motion, and he does, at least it seems at this stage, he's going to claim, have made what I would call separate and distinct arguments about separate and distinct harm that he has suffered.
Well, Your Honor, I, again, referring, and part of the reason why I refer to the appendix at 66 to 67, which is really just the complaint itself, and referring to, for example, the 9th cause of action, Your Honor, and in particular, paragraph 223, the plaintiff is specifically saying and predicating the harm that he has suffered. And if I may, he says they're due to Harvey's breach of fiduciary duties, referring to the defendant appellant, because they're both.
But
both,
you
both
know,
Newmans.
well, I thought you might bring that up too. So I made a copy of the complaint and the 9th cause of action, and it goes on to paragraphs 224, 225, which talk about Charles also being personally liable for the civil liabilities created by Harvey. Again, I know we're not at summary judgment, but we're at 3211. Why can't he make those distinct arguments, even in that cause of action you point out?
Because they're not distinct. He is predicating the personal tax liability that he might suffer squarely on the IRS claim for unpaid federal taxes from 2011 to 2014 that he alleges the defendant appellant caused with respect to the entity. To say it in a different way, if he had not made the claim that the company through defendant appellant suffered this $2+ million tax liability, he would not be able to make the claim that he was suffering the personal civil tax liability. They are interwoven and directly connected. And that's different. That's different from the case, for example, that for the first time, plaintiff appellant cites in the DPB family case, which is a New York trial court case, where in that instance, the trial court found that it was separate and distinct as a personal tax liability for the individual because the individual was able to demonstrate that the personal tax liability occurred specific to him, nothing having to do with the predicate facts in the complaint in that case.
Counsel, I do have one question, not particularly to the case you just cited, but there was a third department case that dealt with personal tax liability, the Yellen case, which, you know, has facts more similar to the case that we're presented with here, as opposed to the underlying facts of Udell. How should we view that particular case?
Thank you for the question, Your Honor. I would view it in a couple of different ways. Number one, what we argued below was that those third department cases, albeit maybe informative, have no precedential value in the first department. And if you were to consider the Yellen case, we would submit in light of Udell, you cannot reconcile them. And so I would submit that part of the reason that for the first time plaintiff respondent submits for this court's consideration these first department trial court decisions is because they are first department cases, one, and then properly presented. Here, those I would submit are more informative cases as to how the court should think about personal tax liability. And that's why I described the DPB family case. There, it's clearer and it's more consistent.
All right, counsel, if you can finish up because we've given you a lot of extra time and you will have a couple of minutes on rebuttal.
I'm sorry, Your Honor. Thank you. I would simply say that DPB, the court's decision there, even though it made a finding that personal tax liability was separate and distinct, on the facts of that case, it's more consistent with Udell and doesn't cause harm or confusion to the first department's deliberation on this issue of how to separate.
We're gonna hear from the respondent, and then I'll give you 2 minutes for rebuttal. Mr.
Durkal.
Durkal. Okay.
Durkal. Thank you, Your Honor.
All right.
May it please the court, John Durkal, on behalf of the respondent, Charles Newman. This is a case where the father diverted $8.8 million of revenue of the company and put his son in a horrific position, subjecting himself to personal and criminal liability. The dividing line between whether you have a direct claim or a derivative claim is clear in most cases. The question is, you look at the harm. Is the harm suffered by the plaintiff a diminution of the value of his stock, or is the harm separate and independent? And we have, in this case, the IRS and the state government and New York State pointing two bazookas at Charles Newman, seeking approximately $8 million in damages from him when you consider the penalties that they assessed as well. And as the Yellen case says, and all the Yellen case is doing is citing what the IRS law is that if you don't pay payroll taxes, you are subject to personal liability that is separate and independent from the corporate liability, subject to separate rules, and it's a very real personal liability that they're coming after him civilly and criminally and going after all of his assets. We've pleaded all the elements of a breach of fiduciary duty claim. We pleaded that there was a breach of fiduciary duty, that existed between the father and the son. They breached it. He breached it, and as a consequence of that breach, we suffered substantial damages. Now, the DPP case is exactly on point. And there was the managing member, right, didn't pay payroll taxes, diverted the money, and the court said, of course you have a direct claim, right, because you suffered a personal liability. Now, the fact that we have a very real personal liability distinguishes all the cases relied on by the appellant. The appellant cannot cite one single case where there was a shareholder subject to personal liability where the court found it not to be direct. So there's not one single case cited by the appellant in this situation. the contention that we commingled direct and derivative claims is ridiculous, right? The law there is that when you do that in a single cause of action, you can't figure out what's direct and what's individual, then those claims are subject to dismissal. In this case, we lay out very clearly in the complaint what claims we are alleging as direct claims and what claims we are alleging as derivative. And so there's no confusion as to what we're claiming are direct and derivative claims. So that argument is really not really meritorious. And as I indicated, we have the liability we suffer is very real. In the Udell case, right, there the plaintiff was, the only damage that the plaintiff was alleging was a diminution in the value of his stock. It didn't involve a case involving personal liability exposure of the shareholder. And it's that personal liability exposure that creates this disproportionate loss by the shareholder. Usually a shareholder has no liability as a shareholder, but in this case, we have personal liability because he didn't pay withholding taxes on behalf of the employees. And I think the court was correct, just like the court, Justice Schechter was correct in finding a proper claim was asserted. And as you indicated, we're at the 3211 stage. Going down the road, where the recovery should be, what the remedy should be, can be decided on a fuller briefing. The final thing I wanted to say is that, our damages are, in terms of what our damages are for the breach of fiduciary duty may overlap with the company, but, is broader than the damages suffered by the corporation. We've incurred hundreds of thousands of dollars in attorney's fees in defending against the criminal investigation, and we may have even additional damages. But the question of damages could be decided, later on, and I think we stated a claim. Unless the court has any questions for me, we rely on our brief.
Judge Gesmer, if you're asking a question, you're on mute.
I know. Do you dispute that there's a separate cause? Do you agree that there's a separate cause of action because of the relationship between the parties?
Well, there's a separate fiduciary duty based on the relationship, right. And I think you said that in Braddock versus Braddock. You made it clear that family members in a business venture have a fiduciary duty to each other. So clearly, there's a separate fiduciary duty. It's pleaded in the complaint, and there's also a fiduciary duty based on the fact that they're 50% shareholders.
Okay. Thank you very much. Mr. Janey, I'll give you just 2 minutes for rebuttal, okay?
Thank you, Your Honor. One, again, I just wish to underscore that this claim of a direct claim premised on an oppressed shareholder or family-owned business is a new claim that was not argued below. It's not in the complaint. It appears in the papers for the first time for the purposes of this proceeding. And again, I would emphasize with respect to the DPB case that it is consistent with the holding in Udell. There, it's not a situation where, and the reason that the personal tax liability was able to be separated is there, the company, the complaint doesn't allege that the company faced tax liability. Here, the claims in paragraph 223 under the 9th cause of action and the claim in the 10th cause of action is specifically, explicitly stated that the personal tax situation that is borne by the plaintiff appellant is created by the tax situation imposed on the business. And that is different. And that's where I believe and submit that the language in Udell, again at 114 to 115, is on point, persuasive, and informative. Even if plaintiff's claims were direct, a complaint, the allegations of which confuse a shareholder's derivative and individual rights will be dismissed. And we submit that is precisely what we have in this case.
Okay, I thank you both very much for the argument this afternoon and enjoy the rest of your afternoon. Thank you very much.
Thank you, Your Honor.
The next case for oral argument is Gutierrez versus Turner Towers Corp. So we're going to hear from the movement first, and then the other three. There were three respondents. I hope you figured out who's going to speak first, second, and third. I don't care the order, you figure it out. But we will hear first from the attorney for Turner and JBS. Okay, counsel?
Thank you, Your Honor. Good afternoon, and may it please the court. Christopher Keene for the defendants' appellants, JVS and Turner. Your Honors, pursuant to two contracts, POFI, the subcontractor, was obligated to indemnify JVS and Turner with respect to this claim. The first contract, the indemnity agreement, entered into in December of 2011, just 6 months before the accident, clearly required indemnification. The lower court completely overlooked the first contract, the indemnity agreement, which was operable, which was in effect, and which governs here. That contract.
Well, maybe that's because there was another contract that was entered into in May 2012, which was supposed to supersede it.
Well, Your Honor, in fact, that contract did not supersede it, and I guess we're really here because of the language of that contract, Your Honor. That contract was entered into between POFI and JVS and included requirements, again, that they procure insurance and indemnify JVS for this accident. Unfortunately, the wrong form was used, and the terms owner and contractor on the AIA form were replaced with contractor subcontractor on the first page over, but weren't carried through to the rest of that document. And on that basis,
Judge Gesmer, you're on mute.
Sorry.
Were you asking a question?
Yes, I was trying to ask a question. I apologize.
Okay. Go ahead.
I'm a little confused by that. You're saying the wrong form was used, but we can only look at the form that's in front of us. And if you're now claiming that was the wrong document, that's the document we have to go by. We can't conclude that they meant to sign something else. Are you really asking us to disregard the document that's in front of us and to substitute what they meant to sign?
No, Your Honor. What we're asking here is that the court interpret the second AIA contract in a way that a number of things that makes sense, that conforms to the course of conduct of the parties, and that avoids what results in an absurdity. The argument and interpretation asserted by POFI regarding the second AIA contract, which required them to do the work, which they did, which required them to get paid for the work, which they did, and which required them to get insurance, which they did. The only thing they're contesting is the indemnity. Under their interpretation that was adopted by the court, JVS, the contractor, and not POFI, the subcontractor, would have done the work that they did and would have gotten paid for it. It creates an absurdity.
Counsel, if I may, when you say the interpretation, that was in fact what the document said, wasn't it? That what the court below determined was what it said is in fact what it said, but it's not what you think it should have said. Isn't that right?
Well, not really, Your Honor, Justice Gesmer. I mean, there's no dispute that the second document had the terms owner and contractor, but what's clear from the course of conduct, which is what should govern and is how the court should interpret the contract, is that it was understood and it was the intent of all parties that those terms would refer to the obligations of POFI as the subcontractor and JVS as the contractor. The court should interpret that AIA contract in a way that the terms are internally consistent. It's not like POFI had a dual role. It was clearly the subcontractor. It wasn't a subcontractor and the contractor. And the court should look at it in a way that makes sense, carrying the first term over through the contract. And this court is empowered to transpose, to reject, or to supply words in a contract so that the contract is clear and to avoid an absurdity. And again, the absurdity here is that under the interpretation followed by the court, it would stand the contract on its head, and POFI adopted and enforced the terms favoring it, getting paid, it did the work, and it got insurance for us, but disavows the indemnity. Further, Your Honor, the second contract in no way.
Well, you're asking, you have a contractual indemnification claim, right?
Yes, Your Honor.
Not a common law indemnification claim, a contractual indemnification claim. So we have to look at the contract.
And Your Honor, Justice Mazzarelli, I would invite you to look at the contract. But in looking at the contract, the court also should follow the course of conduct and follow the intent.
But we don't look at what we call parole evidence outside the contract unless the contract is ambiguous. And looking at this contract is, to me, there's no ambiguities.
Your Honor,
we need to resolve by looking at you look at the course of conduct when the contract itself cannot be understood.
Ambiguous. Yeah.
Right. Well, we would submit that, I mean, the term owner is owner and contractor is contractor. There's no real ambiguity. It's more akin to a mistake or a scrivener's error. And this court is empowered to interpret the contract and, without changing the words, it is allowed to interpret the contract in a way that makes sense. And in fact, the court can reject and supply.
And the scrivener's error would be I'm sorry.
Well, no, I'm sorry. My question was, at the time that this contract was entered into, were the parties represented by attorneys?
No, Justice Pitt. I believe they were both sophisticated parties, contractors, but they did it on their own without counsel. That's how it seems.
So they were sophisticated in that they had entered into other contracts before and presumably would have read what they signed.
Sure. And in fact, Your Honor, it segues into another point, which is that there are really two contracts here that need to be read together. The second contract did not supersede the first contract for three basic reasons. The first is that the second contract had no definitive language beyond boilerplate rejecting the first contract. It's not like they entered into another indemnity agreement and said this one's replaced.
Another problem with another problem with the argument that you're making is that at the time of the accident, there was only one contract that was in effect, right?
Well, no, we disagree.
The May 12 contract, is that correct?
No, Your Honor, that's incorrect. The first contract was in effect, was binding, and was not superseded because the second contract had no definitive language. It didn't deal with the same subject matter.
When did the underlying accident happen?
The underlying accident was in June of 2012, 6 months after the first contract, and a few weeks after the second contract. The second reason why it wasn't superseded was because they don't really deal with the same subject matter. The first one is a blanket indemnity agreement saying to POFI, hey, if you want to do work for us, you have to get insurance, which they did, and you have to indemnify. The second contract was just a form contract for this particular job, and it did not.
I'm confused by what you're saying by just a form contract. It was a contract signed by your client and by the other party, and it said explicitly that it superseded and replaced all prior agreements. And you're telling us that we should disregard that language because it was a form contract that your client signed? No. I don't understand that theory.
Sure, Your Honor.
I'm missing something here.
You shouldn't disregard. The second contract did not supersede, did not fail to supersede the first because it was a form contract. It failed to supersede for three reasons. One, it lacked definitive language saying we're specifically, and there's case law on this we cited in our brief, where it's beyond boilerplate saying specifically, you know what, we entered into this prior indemnity agreement, this scraps that. It was just boilerplate. The second reason— I
don't know what you mean by boilerplate. It's what it said. And if they signed it, then the fact that it was in the printed contract as opposed to something else doesn't make it less important. It's still what they signed.
Well, the cases say that it has to be a definitive repudiation that's explicit. I mean, we've cited those cases in our brief. It's the law.
Didn't it say that it superseded and replaced all prior agreements between JVS and POFI and represented the entire agreement between the parties? That seems pretty definitive.
Well, no, the distinction, Your Honor, in the cases we cited is that basic language such as that is not enough. You have to specifically and explicitly cite the contract you're referring to that you're wiping out. It's in the cases cited in our brief. And more importantly, Your Honors, there's a third reason why it doesn't supersede, and that's because even if Your Honors felt that that these were separate contracts, that the contracts can exist in tandem together. In other words, they're not inconsistent in any way. The first contract, even adopting—
Okay, why don't you finish up, because I've given you more than 6 minutes. It may not have seemed that way, but we had a lot of questions.
Sure. If I might add that the contracts can exist in tandem, even under POFI's interpretation. The second contract doesn't even apply to it, which we find to result in an absurd reason. But on that basis, then how can it supersede the first contract, which did? And if I might briefly address Triborough, Your Honor, Triborough.
You have 30 seconds and
Thank
then
you.
we'll let you respond.
That's all I need, Your Honor. Thank you.
Okay.
Triborough was correctly held in by the lower court on plaintiff's common law negligence claim. There's plenty of evidence as to their negligence, but in an inconsistent way, the court granted their motion to dismiss our client's cross claims for contribution and common law indemnity.
Okay, we got that. All right. Well, Pofi, are you going first or somebody else?
Yeah, I'll go first, Your Honor.
Okay.
I'll address it. I mean, the panel basically addressed most of the relevant points.
Who are you?
I'm sorry. I'm sorry. Patrick Lawless. I represent the defendant respondent, Pofi.
So you look different online here. I would have recognized you in the courtroom.
With your mask on, right, Judge?
I know. Anyhow, I'm sorry, but the panel correctly addressed that the May 30th, 2012 contract, first of all, it contained explicit language saying it superseded the prior December 1st, 2011 contract, and there's no a written obligation in that agreement whereby Pofi has an obligation to indemnify JVS. The contract specifically identifies all the relevant parties. It identifies JVS as the contractor, it identifies Pofi as the subcontractor, identifies Turner as the contractor. There's no indemnification provision in there whereby Pofi, which is the employer of the injured plaintiff, is required to indemnify JVS. And that's an important point because absent a grave injury, there can only be an indemnification obligation upon an employer if it's an express written agreement, which there is none here. And as I said, the panel addressed basically all my points. And unless you have any questions, I'll rest on my brief.
I'll take that we don't have any questions. So thank you, Mr. Lawless. Okay, so how about the attorney for Triborough? That's Mr. Fogarty.
Good afternoon. Thomas
Good
Fogarty
afternoon.
from Triborough. As you said, I have defendant respondent Triborough. I'll be brief. Obviously, we disagree with Turner Towers JVS's contention that Triborough was negligent.
Yeah, I mean, I understand you disagree with that, but didn't the court below on one of the many motions that it decided find that that you would not get out of this case because there was negligence?
Yeah, well, as counsel said, the decision was.
And you're not an appellant. You're just responding to his appeals.
Correct. The court, held there's an issue of fact that's where we were negligent. And that's why they did. But then in dismissing JVS and Turner's cross claims for contribution, they kind of held that we weren't negligent as well. So it's an incongruous decision. The only other point I wanted to make is on the indemnification cross claim. Of course, our negligence isn't enough. They would also have to show that they were free of negligence, and the court held that both JVS and Turner were negligent in failing to dismiss their labor law 200.
So I mean, I think what they were arguing was it was a little premature to dismiss Turner's and JVS's cross claims for contribution and common law indemnity against you, since we haven't gotten to the point yet of figuring out who is actually negligent in this case. I mean, we didn't have a trial or a settlement yet, right?
Right. But I mean, I understand the argument regarding contribution claim, but the indemnification claim should be dismissed, as the court held that JVS and Turner were negligent themselves and therefore precluded from bringing common law indemnification claim against Triborough.
Okay. Anybody have any further questions there? Okay, well, thank you, Mr. Fogarty. So now we can hear from Mr. Shaw for the plaintiff. Is that correct?
Yes, thank you, Your Honor. May it please the court. Plaintiff in his argument did not address my client. This is about a clear cut of a 240 case as it comes. The record is indisputable that the plank broke, it failed, and my client fell approximately 10 feet. There were no barricades, no protection. I mean, unless the court has any questions for me, I certainly will rest on my brief. And certainly also with respect to negligence, Mr. Remo was told by Mr. Gonzalez, the rep from POFI, the day before about the about the planks being in seriously bad condition, and they did nothing about it. So clearly the negligence claim stands as well. And Triborough, which the court touched on, said there was an incongruity with respect to the negligence decision. Well, the reason the court kept them in, which they did not appeal, was based on Mr. Remo's memo, page 1563 of the brief, or the record, where he said he spoke to the representative the day before from Triborough about the seriously shoddy plank, and nothing was done the day after. So, unless the court has any other questions for me, I'll rest on my brief. Thank you.
Okay, thank you, Mr. Shaw. So we now go back 2 minutes for Mr. Keene, I believe, the appellant.
Thank you, Your Honor. Your Honor, with respect to POFI, I would just point to a few things. One is that the first page of the second contract, the AIA contract, in fact, specifically referred to the parties as contractor and subcontractor. That was the intent, that they would be bound as the subcontractor. The fact that the terms weren't carried through is not dispositive. Again, this court is empowered to interpret it in a way that makes sense. Additionally, Your Honors, even if you interpret it differently, the AIA contract, the second contract at section 11.3, in fact, specifies that the subcontractor under that agreement, which the owner wasn't party to, mind you, but the subcontractor agrees to assume all responsibilities that the contractor would have to the owner. Therefore, even if if the court adopts that interpretation under that contract, the subcontractor POFI is obligated to indemnify here. Thirdly, with respect to the supersede issue, I would just direct Your Honor's attention again to two cases cited in our brief, Cascades and Globe, which address the issue of the requirements for a second contract to supersede the first, which we submit are not met here. Briefly, with respect to Triborough, I think counsel misspoke. There was no finding by the lower court that JVS or Turner were negligent. It was only a finding on.
I was going to ask that. I didn't see it.
Yeah. So therefore, I think it's just clear there was an inconsistent result. We would be entitled to common law indemnity in addition to contribution, as long as there was no negligence on our part. But that's to be found.
So you just didn't want those claims dismissed. You're not looking for anything more than that at this point.
Right. Triborough should be in against both of us, because otherwise, how are we going to proceed? Lastly, with respect to plaintiff, I'll rest on the papers, but I think there's enough here to raise an issue of fact as to whether the failure to use the available harness that he had, that he knew he was to use, should have.
I mean, I don't want to really get into it much, but didn't somebody testify, I forget which person, that there was no place to connect the harness on the sidewalk bridge because they don't usually have those kinds of, they don't use those kinds of safety provisions on a sidewalk bridge.
That was the claim. Right. That was the claim, Your Honor, but it turns out that was actually speculation. They asked the person from JVS, was there one? And he said there aren't usually. They didn't follow up. There's no proof that there wasn't one. And just one last thing, if I might.
No proof that there was one.
There was no, so they didn't meet their burden showing that there was no available. It was just speculative testimony. Lastly, one point I failed to address, Your Honors, regarding POFI is that they simply did not meet their burden on their motion. They submitted no affidavit or testimony from anybody from POFI disavowing either of the contracts, saying, hey, we never intended to indemnify. It was just attorney argument. They didn't meet their burden with any support from anybody from POFI, and the court should have denied their motion.
Okay. Thank you all very much. Enjoy the rest of your afternoon. The next case we have for argument is L&M 353 versus Steinman.
Good afternoon, Your Honors. Michael DeSantis. May it please the court, on behalf of appellant defendants Ari and Sonata Steinman. Respondents have a judgment against a limited liability company. They wish to hold appellants as members of that limited liability company responsible for that judgment. They filed the
Counsel, in order to do that, don't they have to first establish that the company was insolvent, that it couldn't meet the, and that some improper actions were taken by it to avoid its debt? I don't see that, and it seems to me they could have very easily done that if they had pursued post-judgment disclosure, which they chose not to do. And in the absence of that, I don't see how the individual members of the corporation of the LLC can be held liable.
I agree with you entirely, Your Honor. I represent the individual members of the LLC.
I'm sorry. Sorry, I had
But thank you.
Sorry.
So the complaint contains a single cause of action sounding in personal liability for LLC debt, which is not a legally cognizable cause of action. Respondents argue that, well, it's simply poorly pleaded. It is an action for fraudulent transfer. However, they don't identify any fraudulent transfers. The Supreme Court in New York County allowed them to escape a 3211 motion relying on 3211D. However, this court in RTN Networks LLC v. Telco Group Inc. and Carlisle LLC v. Quick Park overturned decisions by the Supreme Court in New York County on very similar facts. The law in the First Department is a plaintiff cannot rely on 3211D to assert a fraudulent conveyance claim upon information and belief. There are no allegations of any improper transfers in this case. The only transfer alleged occurred in 2014. It is undisputedly for consideration. And
That's
that
when
transfer,
the property was sold, correct?
when the property was sold, prior to the commencement of the lawsuit from which the judgment emanates.
And the judgment wasn't even entered to 2018 or 2019, is that correct?
Not only was the judgment not entered, the lawsuit from which it originated wasn't even started. Respondent asked this court to infer improper transfers. There's no evidence of improper transfers. There's no allegation that any transfers were made not for consideration, outside of the normal course of business, nothing. Frankly, if that were the law in the First Department, every judgment debtor with a judgment against an LLC could start a lawsuit against the members with a showing of no evidence.
Counsel, is there any requirement that the judgment creditor had to start supplementary proceedings to try to collect the judgment some other way before bringing this action?
No, there's no specific requirement, but they also can't feign ignorance as to the facts that they claim they can't plead in the complaint. This information is available to them. Under 3211D, to seek the relief, you need to show an affidavit explaining what facts you're seeking, detail those facts, and third, explain that they are solely in the possession of the party for whom you seek them. These facts are not solely within the possession of Ari and Sonata Steinman. They have an array of post-judgment discovery that they could pursue against Esland, the limited liability company against which they have a judgment. That would entitle them to discover any transfers at all. They have the authority to get right now. They just need to send a discovery demand. They chose not to do so. I can't force them to pursue post-judgment discovery, but they can't feign ignorance. This information is not solely within the possession of the appellants. So they failed to meet the requirements of 3211D. They failed to adequately articulate any claim. They allege it's a fraudulent transfer. Okay, when we look at the respondents' papers, we can't tell whether it's a actual fraudulent transfer where they need to allege intent, a constructive transfer where they would need to allege some kind of insolvency. There's elements argued about common law fraud. We clearly don't meet the requirements of CPLR 3016 with this complaint alleging no facts.
Well, I don't know if 3016 applies to all of the debtor-creditor law causes of action, but I mean, there does need to be some type of start here in putting together some factual allegations. Seems to be at least part of your argument.
That's correct, Your Honor.
Okay, we've given you 5 minutes. I'm going to listen to the respondent. We're going to listen to the respondent, and then you'll have 2 minutes for rebuttal, okay? Thank you, Mr. DeSantis. Mr. Gordon?
Stephen Gordon for the respondent. May it please the court, opposing counsel. I think it's a good place to start at the beginning of the whole dispute between my client and the appellants.
Mr. Gordon, I have a question. I'd like you to respond to Mr. DeSantis with respect to RT and Carlisle, because it seems to me that that would be controlling. Why shouldn't we apply those cases here?
Because neither of those cases actually address 3211D. I'm not sure where appellants pulled that from, but there is no mention of 3211D whatsoever in that case, nor is there any indication that it was even argued. The facts of that case materially differ.
Because it seems to me that it's on point, because there, I mean, this court reversed the denial of a motion to dismiss a constructive fraudulent conveyance claim, where the allegations were very conclusory and sparse. And certainly, similar to here, I don't think there were any facts pled about the conveyance was made without fair consideration.
Well, so here the fair consideration, I concede that we are asking the court to infer that there was no fair consideration made, because the S.Land is unable to satisfy this judgment. What happened was they—
Well, wait. Can I ask you, Mr. Gordon, I'm sorry to interrupt you, but you say they're unable, but have you ever attempted anything to try to get the money from S.Land? Because it seems, like I said before, that there have been no supplementary proceedings, which we might normally expect to see when a judgment has been entered and there hasn't been payment on it.
We filed to collect on the judgment. It hasn't been satisfied. This is after they conceded.
Counsel, may I ask you, where does that appear in the record? I didn't notice anything in the record showing that you had made any attempt. I mean, you said that they didn't pay the judgment, but I didn't see anything in the record that showed that you'd made an effort to collect the judgment and that you had been unable to do so, or that they were unable to pay it.
Yes, I'm not going to say that the complaint was artfully pled, nor that anything in the record at this early proceeding. We are still at the very first stages of this proceeding. We really relied on S.Land and their two members, their sole members. This is completely an alter ego of the appellants, and they have not denied that. They have not denied any sort of, they have not denied that the transactions occurred to them. They have not denied that the company doesn't have money. They are completely feigning ignorance. If I may, I think the case that's actually more on point here is a matter of Setters.
Mr. Gordon, I'd like to go back because you didn't address Carlisle, and Carlisle seems to me very similar here, where all of the substantive allegations are made upon information and belief. And once again, no allegation with respect to lack of consideration. So can you address Carlisle and why that's not controlling here?
Yes, I mean, Carlisle differs because we don't have the situation here where we had appellants through their company. They agreed to stipulate to liability in a prior case. They did not appear at the inquest hearing. We got a judgment against them, and then we find out that they did this because they knew that they had liquidated the company. It's not impossible to infer that. It's very reasonable to infer that. Why would they stipulate to liability, not appear at the inquest hearing, and then say that you have to take this extra step. You have to conduct post-judgment discovery where they could have transferred the money to a different entity, and then it could have gone so many different directions. The way that we find out exactly whether they are the transferees is by instituting this action. At some point, we would have had to institute it anyway, because they are the ones who controlled this company, this LLC. They are the ones who caused this transaction to occur. That is very different than what happened in Carlisle. Carlisle didn't have any of those facts. And RTN, likewise, also didn't have the situation here where fair consideration, the fact that there's no fair consideration is inferred by the fact the company refuses to satisfy the judgment. They are claiming that there's no funds to satisfy the judgment. And now we are trying to collect upon it, and they will not even address the actual allegations as to whether there was a transfer that occurred. I'd like to bring up the matter of Setters versus AI Props developments. It's 139 AD 3D. In this action, the first department considered whether the plaintiff had properly pled actual intent for under DCL 276, and they actually found that solely based on the fact that the respondents were the sole members of the LLC, there was a judgment shown. There was a judgment shown against them. There was no adequacy of consideration, and they were aware of the petitioner's personal injury claim. And it wasn't even them being aware of it. It was the LLC that was aware of it. And the court found that from that, since the defendants failed to provide any evidence to negate the inferences of intent, they did not dismiss the complaint, and they overturned the lower court's ruling.
Okay, any further questions, colleagues? Okay, thank you very much, Mr. Gordon. Mr. DeSantis, you have 2 minutes to respond to anything you'd like to respond to. Mr. DeSantis, you're on mute.
Still happens sometimes. My apologies.
Yeah, I think I'll remember this time best by saying to people, "You're on mute. You're on mute." Okay.
I don't see Setters in the table of authorities in the brief for plaintiff respondent. I'm not familiar with it. RTN and Carlisle are controlling here. 3211D certainly was argued and was addressed by the Supreme Court in New York County. The decisions and the motion papers are a matter of public record and are available on NYSEF. Respondents' counsel has argued a number of facts that are not in the record. There have been no efforts to collect on the judgment. There's no post-judgment discovery. There's been no discovery in this case. Upon information and belief, respondents don't seek discovery. They seek leverage. And as respondents' counsel stated, the way we find out if the money went to the members of the LLC is by bringing this lawsuit. This isn't a discovery action. Even if it was an adequately pled fraudulent transfer complaint, we look at the whereas clause. They're not seeking to void any transfers. They're seeking to hold members of an LLC personally liable, and they haven't pled anything that would allow them to do that. Unless your honors have any questions, I'll rely on my brief.
Okay, thank you both very much. Appreciate it. Enjoy the rest of your afternoon.
Thank you.
The next case for oral argument is Yakik versus Department of Education. Mr. Yakik, you have 5 minutes for argument. I know you're representing yourself, but you've been watching the whole afternoon, I see, so I'm sure you'll handle it just fine. Okay, you may begin. But just unmute your microphone, please.
Okay, am I unmuted? Can you hear me?
Yes, we can.
Okay. Good afternoon, Your Honors. My name is Yakik Rumley. I'm pro se litigant. I had a statement written. I'm going to try to get through as best as I can. After so many years, my request was denied and dismissed because of a technicality, a misnomer, a comma. I'm a pro se litigant and was not afforded an opportunity to be heard. I'm seeking equitable relief and discretion of the court to be simply heard. It should be noted that the DOE doesn't assert that the papers that were submitted were not timely served or received. The DOE is fully familiar with this matter as there's no prejudice in the case being heard. I have had 26 job offers rescinded, 19 full-time and 7 part-time rescinded due to non-DOC clearance and giving me the opportunity to teach full-time physical education. Yet I have received clearance from the Department of Department of Health and Mental Hygiene, but yet every time get denied from OPI, where they have a system where when you get denied, you have to wait 12 months to go before OPI and yet every year they keep rubber stamping denial. I have 3 certificates of relief and a sealed violation. My certificates of relief relieve the holder of the forfeitures, disabilities, and bars hereinafter enumerated employment as a teacher of physical education with the New York City Board of Education, employment background clearance, and career advancements. These certificates are deemed to be permanent now. Yet the DOE continues to use abuse of power and arbitrary and capricious and deny me full-time clearance. As of now, I'm juggling 6 part-time jobs as a recess PE teacher for PS 234, 92Y, Kids in the Game, Superstar Tennis, Asphalt Green, and Huddle Up New York City. All these entities have accepted my certificates of relief, and I work 7 days a week. All of my 26 job recensions was not based on my merit and professional experiences, rather recensions due to non-security clearance with OPI. The fact that the judge sealed a case with a student which occurred 14 years ago indicates that I don't pose a reasonable threat to students or the general public. I continue to work with students today in various school locations, community programs today, and other part-time roles. My part-time roles at academic and community programs have made me successful. I continue to receive letters from these various employees advocating for full-time clearance. Yet, every time I go before OPI, they deny me clearance each and every time. These part-time roles have accepted my certificates of relief. In addition, they have written letters on my support, including the principal, saying that we'd like to hire Mr. Rumley as a full-time phys ed teacher. I've demonstrated through my community service that I've been rehabilitated. And my goal is simply just to become a full-time physical education teacher with the New York Public Schools or an athletic director or athletic administrator. I don't know what else more I could do. I go before OPI every year. I submit new letters, including more recently from Senator Al Taylor, Reverend Nathan McCall from the Natural Action Network, other advocates from the church that go on my behalf and say, we don't understand why you continue to deny Mr. Rumley clearance when I'm working in my field now, but no benefits, and I continue to work on a part-time basis.
Do any of my colleagues have any questions? Right, why don't we listen to the other attorney, Mr. Is your first name Yakik or your last name?
Yes, Yakik is the first name, Rumley is my last name.
Okay, I'm sorry I called you Mr. Yakik. I was wrong on the papers. All right, Mr. Rumley, why don't you listen to what the other person says, and then we'll give you a couple minutes for rebuttal. Thank you very much. Counsel for respondent.
Thank you, Your Honor. May it please the court, Jeffrey Stannard for the Department of Education. Just a couple brief points in response. First, regarding petitioner's failure to name the department in the caption. His arguments on this point, he mentioned the misnomer and the comma. These aren't arguments that he raised below, so we would ask them to be, these arguments to be rejected as unpreserved. Second, while there are many situations where it's appropriate to afford a pro se deference, here the issue is purely jurisdictional. He failed to name DOE as a respondent, and under the CPLR 1003, dismissal is warranted when a necessary party is not added as a party. And as the court pointed out below,
you're from the Corporation Council, is that correct?
Yes.
So you would still be representing the department if they were properly named, right?
Yes, that's right, Your Honor.
Okay, so I'm trying to figure out what the prejudice is here.
We're not arguing that there's prejudice. We're arguing that the court below was correct in holding that it didn't actually have jurisdiction. Jurisdiction never attached here because DOE was not named. He named OPI, which is an office within the department and is a non-suable entity.
Why don't you go to the merits of the claim? I think we got your argument on the procedural aspect.
Sure. So if this court does go to the merits, the decision can be upheld purely on facts that are not in dispute. Namely, the petitioner made false statements on his application regarding his prior employment history. He doesn't dispute that he filled out the form incorrectly, that he basically essentially concealed the fact that he had previously been employed by the department, and his employment was terminated regarding an incident where he had a physical altercation with a student, and which led to his arrest. He said that he had never been employed terminated from employment before. He acknowledged that that wasn't true. On that basis alone, Chancellor's Regulation C-105 permits the department to deny an application purely based on falsification of prior employment history. So the court doesn't even need to get into his criminal history, but there are these additional factors that OPI considered, including his 2015 felonies, which were numerous, and raised concerns considering that he was applying for a position in which he would be working directly with the student population. And finally, the incident itself, not only the fact that he didn't identify the incident in his application, but the incident itself created concerns because he had this altercation with a student. He was applying to have further contacts with students. So these three separate reasons provided ample basis for the department to deny his application for a security clearance.
What about some of the letters he's put in support of his yearly request to OPI to allow him to do this work? Should we consider that? Did you consider that, I guess I would ask?
Yes, the record is clear that the department did consider all of those letters and considered his certificate of relief from disability.
Right.
The fact is that that's not a certificate of relief from disability is not dispositive. The department has to consider all of the facts in tandem. And here, although it did consider his letters of recommendation and his certificates, there were just too many concerns based on the other factors.
Anyone have any questions? Okay, Mr. Rumley, if you'd like to respond, you have 2 minutes.
Yes. First of all, I definitely want to deny the incident with the student. For one, in 2008, we had a situation where the gym was split between Wiley High School and Frederick Douglass Academy. I prevented a student from attacking another student in my classroom when he came in with a knife. And at that time, I had to basically hold the student down while they went to get security. I said that during the time. I said, this is what happened. Every time I go before OPI, I would say, well, what do you expect someone to do if another student is coming in with a knife? They never gave me a response to that. They said, well, you're just on your own. So every time I go before OPI, they continue to bring up what happened in 2008, despite the fact that I've mentioned that I prevented someone from being stabbed in the classroom, not me physically altercating a student. In terms of 2015, there's an affidavit in my brief. I was a basketball coach with the Westchester Knicks. I was in Vegas during the time that this occurred, and someone that I knew from the club scene was using my apartment during the time. So the arrest was in 2013. I depleted all my 9/11 savings account, where it took 2 years. The lawyer that had the time put in a motion for the case to be dismissed because they had no evidence. And instead of it being over 180 days, the judge gave like 172 days. And the lawyer asked me, well, you're going to have to give more money if you want this case to continue. I'd already depleted all my savings account resources. So he said, just take the plea and you'll be off probation in 16 months. And that's exactly what happened. So here's what happened in 13. It took 2 years. I took the plea and I was on probation in 16 months. And from that point on, since 17, I've been asking for clearance. I've written 3 books since this has happened. I brought those books to OPI every single time. I'm the president of the prison ministry. I've done college fairs for Hampton University Alumni Association. I've had principals, aides, other advocates on my behalf, including Senator Al Taylor, said it's ridiculous that they continue to bring up something from 14 years ago. And I don't believe that the 3 judges who've given me 3 certificates of relief would say that they want me for the rest of my life to work part-time jobs and not provide me with full-time clearance. I just don't believe that they will put that permanent. But then he's saying, well, no, we have the authority to say no. So that means basically for the rest of my life, I should be working part-time jobs and continue to get rescinded on offers every time a job offers me clearance, when the Department of Mental Health and Hygiene have already said, we've already granted you clearance. And I showed that to OPI, Department of Education, and they said, we're overriding what they're saying. We're not giving you full-time clearance. And then it's back to juggling what I'm doing now, a rotation of part-time jobs and helping my mother out, who's, basically I was relying on my help.
All right, Mr. Rumley, thank you very much for your cogent arguments. Thank you, Mr. Stannard, for your arguments. We'll take another look at these papers, and good luck to both of you, and have a good rest of the day. Okay, thank you for coming in.
Thank you.
Thank you.
And I believe the last case for oral argument is Wells Fargo versus Hayden.
Yes.
That correct?
That's yes.
Okay. Mr. Silverberg, you're the appellant, correct?
That's correct.
Okay, you may begin.
Thank you, Your Honor. Your Honors, may it please the court, good morning, good afternoon. This is a foreclosure case that started in 2009 and has been delayed in resolution by various means and excuses, but here we are 12 years later with an unresolved case. I mentioned in my briefs I think 9 principal points. I will just deal with the main ones in the time I have.
Thank you.
The first point that I would like to make is that the plaintiff in the motion for judgment of foreclosure and sale did not serve the defendant with a copy of the order and notice of entry. It was served by a co-defendant who was in fact the condominium board that was involved in the case because of their seeking arrears.
Counsel, if I may ask, what is the basis for your claim that service by somebody else was not effective?
My claim is
there a statutory basis on which you rely that service by the condominium board didn't have the same effect?
Yes, Your Honor. CPLR 2220A, which has been in effect since 1962, requires or has been interpreted to require that service be made by the prevailing party in the motion.
Counsel, I have a question. Did you raise that argument below? Because I don't recall seeing that in the papers. Did you raise that below?
Yes, I did. I did it first in the order to show cause, where I mentioned that the sale of the property would be improper, illegal, invalid, because the client was not, the defendant was not served with a copy of the order with notice of entry. And I distinguished that from other discussions dealing with the manner of service or the commencement of the 30-day notice, the 30-day time to file a notice of appeal. As I said,
can you point to the record, a page where you made the CPLR 2220 argument? Because I just don't see it.
I made it without reference to the number of the CPLR section, and requested at oral argument if the court wished that they give me a brief adjournment, and then it was made explicitly in the motion to re-argue. And I could give you the pages for that if you wish.
Well, maybe can you go on, and maybe on rebuttal you could give us the pages so that we could, could go on to some of the other issues, because it's a long case with a lot of arguments. So perhaps
I know
you could do that on rebuttal. Give us the pages.
I could give you right now if you wish. 2220 was argued in the first mentioned on the order to show cause, and then on oral argument, and that's at page, and the transcript of the argument is at pages A160 to 170.
Okay, thank you.
And then on the motion to re-argue, pages
78 to 80, explicitly citing the section 2220A. But as I opened my oral argument in the Supreme Court, if I could just briefly recap that, the point that I was making in my papers is that the notice of entry serves two purposes. It serves the purpose of starting the clock on the losing party appealing an order, a judgment, but it also is a fundamental precedent, condition precedent to the enforcement of the judgment, which are two separate areas of the CPLR, and as much as the respondent would like to ignore it, it can't be ignored.
Okay, counsel, because we've already gotten through pretty much 5 minutes, let me ask you one other question on a different issue. I know a lot of your brief was talking about a lot of the prior orders that your client never appealed from, rather than dealing with the orders that you say you're appealing from. So it's a very, there was a lot of history in this case. How are we going to deal with those old orders if they were not actually appealed from at the appropriate times?
Well, the order that is appealed from is a judgment of foreclosure and sale that was granted to the plaintiffs in 2019, and the appeal was timely filed. It was a resettlement of an original judgment and 3 other attempts at a judgment of foreclosure and sale, which were rejected by the court for various reasons of lack of completeness or error, or failure of the plaintiff to appear at a oral argument on its motion. So you got 4 times that they tried to get a judgment of foreclosure and sale, but never did get one that, as resettled, has substantial differences from the original judgment. One is the forgiveness of interest from 2016, the time of the original judgment, because of their unexcused and unexplained delays in prosecuting the case. So
okay, counsel, I'm going to have to stop you right now, but because a lot of this I know I did read in your briefs. So can we hear from the respondent, and then you'll have a few minutes to point to anything you'd like to point to. All right, thank you very much.
Thank you.
Respondent.
Good afternoon, Your Honors. May it please the court. My name is Adam Weiss of Stradley, Ronan, Stevens & Young. I represent the plaintiff respondent in this appeal, Wells Fargo Bank N.A. as trustee. The court is correct that the appellant has failed to raise the issue concerning CPLR 2220 in the lower court. The only argument that appellant made in the lower court concerning the November 15, 2019 order, which is one of the 2 orders on appeal here, is that there is a violation of CPLR 5513. So he's arguing a completely different statute on appeal. Therefore, the court should not hear this appeal, and it should be dismissed for that reason alone. Even CPLR 5513 was actually amended in 1997 to remove the requirement that a prevailing party must serve a notice of entry. Therefore, the notice of entry of the July 23, 2019 order, which is the other order on appeal here, was properly served by our co-defendant. Even if the court were to consider appellant's new argument under CPLR 2220.
But that doesn't apply here, does it, counsel?
No, it certainly does not, and that is correct. First, appellant doesn't even set forth any reason in her brief as to why CPLR 2220 provides any grounds for reversing the trial court. And second, the plain language of that statute does not even support any of appellant's arguments. With respect to the July 23rd, 2019 order, which is also on appeal here, appellant has set forth absolutely no arguments in her brief concerning this order, and therefore I would argue that that appeal should be considered abandoned and dismissed. Even if the substance of that appeal is of the appeal of the July 23rd, 2019 order is considered, the trial court did providently exercise its discretion pursuant to CPLR 2004 to extend the time to hold the foreclosure sale. There was good cause for the delay in holding the sale because the county clerk had refused to enter the resettled judgment of foreclosure and sale. And just to touch on the court's other point concerning the prior orders that appellant has raised in her brief, the respondent submits that the majority of that brief from points 1 to point 8 should be disregarded because those prior orders cannot be reviewed on this appeal. Counsel is incorrect that a judgment of foreclosure and sale is being reviewed here. That is not correct. There are two non-final orders here. The July 23rd, 2019 order was a ministerial order, and that order merely granted respondent's motion to vacate the original judgment of foreclosure and sale, directed the county clerk to enter the resettled judgment of foreclosure and sale, and extended the time to hold a foreclosure sale. And the November 15, 2019 order denied the appellant's motion to stay enforcement of the resettled judgment of foreclosure and sale and to stay the foreclosure sale. Under CPLR 5501A1, these cannot be reviewed because they are not appeals from a final judgment. The appellant has failed to appeal any of the other orders, and therefore they should not be brought up for review. The appellant has also defaulted on the motion for summary judgment, as well as the motion to resettle the judgment of foreclosure and sale. So for those reasons as well, those orders cannot be appealed.
So you're saying that this July 2019 judgment is not a final judgment?
No, the judgment of foreclosure and sale that was entered in this case was the final judgment. Pursuant to a case that I had cited, NAB Asset Venture for v. Orangeburg Equities, 19 AD 3D 565, a judgment of foreclosure and sale entered against the defendant is final as to all questions at issue between the parties and all matters of defense which were or might have been litigated in the foreclosure action. The orders being appealed here do not qualify as final orders under CPLR 5501A1.
Okay.
And therefore, we ask that the court dismiss both appeals.
Okay. Any questions? Okay, Mr. Silverberg, you have 2 minutes to respond to anything that Mr. Weiss has said or anything else you'd like to bring up for our attention.
Thank you, Your Honor.
You're welcome.
Just going in not quite reverse order, but the issue of the judgment of foreclosure sale being non-appealable. The orders were non-final, or post-judgment orders, and there is ample evidence, and the case I cited were Second Circuit cases, that in a normal civil case, the court would entertain an appeal of a post-judgment order, except where, for example, in the cases they say a discovery motion, where the court wouldn't entertain a motion concerning discovery. But as to the kinds of substantive issues here, I believe that the governing order, the governing decisions are the federal cases that I cited in my brief, particularly in the reply brief.
Okay, well, we will take a further look at the cases that you both cited and the issues that you bring up. I appreciate your time and you're coming in, or you're appearing before us virtually this afternoon. I believe this is the last case to be argued this afternoon. So this concludes oral arguments for today, and court is adjourned. Hope everybody has a lovely evening.
Thank you, Your Honors.
Thank you, Your
Okay, bye-bye.
Bye.